Good morning, everyone, and sorry for the delay. There's nothing like kicking off a Wednesday with technical difficulties. I do apologize. I know everybody's already short on time, but I will let you know that this will be well worth your wait, and super excited to have Tom here with us. My name's Erin Kopek, and I'm the VP of Marketing for Higher Level, and you have joined our High Notes program. Tom Berry has been an annual presenter for us. He's an attorney with Jackson Lewis, and happy to have him back for an Illinois employment law update today. A quick bio about Tom before we get started. He is a principal of Jackson Lewis in St. Louis. Tom's practice is exclusively focused on representing management before state, federal, or local administrative agencies. His practice is national in scope. He has represented employers in legal proceedings in over 20 states. Tom has extensive litigation experience, which permits him to effectively counsel and advise clients on a variety of employment-related issues. All right, Tom, I'm going to put you on the spot, and we will do questions at the end of the webinar today, and this will be recorded and shared at the end. So, Tom, I pass it off to you, and thank you for joining us.
Thank you, Erin, and more importantly, thank you all for your patience as I was navigating my technical problems. So, hopefully this is not a omen for the rest of the day, but certainly I will. The 10:30 is not a hard stop, so I've got a lot of information to go through, and then I'll take as much time after the presentation to field as many questions as we can with the presentation. So thank you for your patience. And there's a lot to talk about in terms of, employment changes for Illinois employers moving forward. We're going to talk about, first of all, the Paid Leave for All Act that becomes effective the 1st of next year. I'm also going to talk about the Temp Worker Fairness Protection Act that, again, will become effective here right now next month in November. I'm also going to talk about the new law coming to Illinois about salary and benefit disclosures and all employment applications. The good news is that will not be effective until January 2025. We'll talk about changes in the Illinois gender violence law and the seemingly annual changes to VESSA, the Victim Impact Enforcement Safety Security Act. We'll also talk about changes to bereavement rights for Illinois employees. And then finally, we'll talk about a couple of minor issues arising from the Personnel Records Review Act, organ and blood donors, and then also a new provision for those employers who may also have independent contractors assisting their operations. First, I want to kick it off about the Paid Leave for All Workers Act, which is, again, driving a lot of inquiries now because it's coming on board effective January 1, 2024. This was a law that was passed during the lame duck session in Springfield last January. It was fast-tracked, literally. It was introduced on January 6th and passed both houses on January 10th. And that's an even shorter tenure when you realize that there was a Saturday and Sunday from January 6th to January 10th. So it's essentially 3 legislative days from introduction to passage. It was then signed by the governor in March. One of the changes, I guess the good news is, one of the changes in those 3 days is it was originally going to be effective when it was signed by the governor. So at least it was delayed until the beginning of this year. And starting forward, every Illinois employer, regardless of the number of employees, with a few minor exceptions, is going to have to provide a minimum of 40 hours of paid leave benefits to the workforce for any reason, for any time. Again, it covers virtually every employer. I think the only exceptions are, for whatever reason, FedEx and Amazon had good lobbyists, so their employees are excluded, and employees of school districts and park districts are excluded. Other than that, everyone is covered in Illinois, whether you have 1 employee or 1,000 employees. And again, they're going to be entitled to accrue at least 40 hours of paid leave that they can use in a 12-month period of time. And the employees, can either be granted the 40 hours on January 1, or they start earning it on January 1 at the rate of 1 hour for every 40 hours worked, up to a cap of 40 hours. For exempt employees, they're just granted 40 hours that they accrue during the year. And again, it has to be taken at their regular rate of pay. For those of you who may have restaurants and have tipped employees, they have to be paid at the minimum wage rate, not the tip credit rate, if they take paid leave. The employee has the right to take the time off for any reason with, and do not have to provide any documentation. So if your employment policies require that, we're gonna have to tweak them and revise them to ensure that at least for a minimum 40 hours, employees, have essentially the right to take leave on the whim of a moment. Now, this act does not apply to employers who are otherwise covered by a municipal paid leave ordinance. Practical impact, that's just Chicago or Cook County employers. If any other municipalities pass paid leave, which they haven't so far, they have to meet the minimum of the state statute now. If you have employees that are covered by current collective bargaining agreements, the act is not applicable to those folks until the agreement expires and you negotiate a new one. Collective bargaining agreements can exclude coverage of the paid leave statute if that's agreed to by the union and it's clear and conspicuous in the agreement, but that's just any new agreements after January 1. Any current agreements, it's not applicable till that agreement expires and you enter into a new agreement. We're going to talk about in a moment how we have to harmonize the paid leave statute if you already have vacation, personal, sick, or PTO policies that provide employees 40 or more hours. So first I want to talk about what you have to think about is, do you want to front load the 40 hours at either the beginning of January 1 for current employees or on day one of employment for all individuals who are hired after January 1 next year. The benefit of front loading is it becomes a use it or lose it benefit. So if you give the employee front loaded 40 hours on January 1 and they don't use it all by December 31, it's gone. They get another front loaded in the next year, but it's use it or lose it. If you don't accrue it at the beginning of the employment of January 1 and you require them to accrue it at a rate of 1 hour for every 40 hours worked, then whatever available time they have at the end of this next year will roll over to 2025 and they will continue to accrue paid leave rights again at the same formula, 1 hour for every 40 hours worked. You can, however, limit the number of state leave hours they take in 2025 to no more than 40, which results in a bank, building. In terms of employees wanting to use their paid leave, you cannot insist that they have to use, the full 8 hours. If they want to use just a partial day, you can limit to no more than 2 hours. And so if they take off an hour, they have to burn 2. You can allow them to use what they use, but at a minimum, you can insist that they use it at all. It has to be in a 2 hour or more increment. Now, the statute requires the employee, if they need leave for a foreseeable reason, to provide you at least 7 days advance notice. If the leave is not foreseeable, child wakes up tomorrow morning burning a high fever, they have to give you notice as soon as practical under the circumstances. But the challenge here, and this is something that we'll hopefully get some guidance from the Illinois Department of Labor, is again, the state statute prohibits employers from demanding the employee to specify the circumstances and the reason for their use of the state leave. So how do we know if it's foreseeable or not foreseeable if they don't have to give us a reason? So this is something the Illinois Department of Labor has promised to provide some practical guidance. But right now, the way the statute is written, there's potential that you could come to work one day and your entire workforce decides on the whim to take a day of paid leave on Friday, and you get 0 advance notice. So I think the DOL is aware of the operational challenges here, and they're trying to finesse it, but this is something we have to watch for guidance in the next 2 months. So again, as I mentioned, this does not apply if you have employees in either Cook County or the city of Chicago. Again, the union employees are not governed until their contract renews. And the good news is, if you keep the state leave benefits separate from either your vacation policy or your PTO policy, there's no legal obligation to pay out the accrued but unused time at the time of separation. However, if you treat it all covered by your PTO policy, then whatever hours they roll over year after year after year will have to be paid out at the time of separation. So again, going back to, do you consider whether you accrue it on the front end on a use it or lose it basis, or do you require accrual? So challenges for employers, obviously, the operational challenges of everyone calling off at the same time. The statute doesn't permit you to provide a blackout period for when people can use it. If there's a particular period of time that's busy for your practice or your operations. And again, if you have unlimited PTO policies, you now add another week, to be beneficial here, you may be increasing your payout obligations on the back end. And so, the challenge by having them separate versus combined goes to the payout obligations. The only time you have to pay out unused time is vacation time. So if you keep vacation separate from sick, separate from personal, and even separate from state paid leave, you only have to pay out the unused vacation, and you don't have to pay out unused sick, personal, or paid leave. If you combine them all, you're gonna have to pay it out. So a combined policy has the practical benefits of easier administration. Employees understand it better. They have a total of 100 hours, 80 hours, 160 hours, whatever their PTO policy bank is, and it's easier for you to track it. But again, it may have greater financial consequences at the time of separation. Separate policy, again, allows you to keep your payout obligations minimized, but is a lot greater administrative burden to track the separate time. And again, that will be a challenge, particularly for smaller employers who may not have a robust HR department. And then finally, if you have separate buckets of time, whether vacation, personal, sick, or state leave, the employee gets to choose which bucket they use from. The employer cannot mandate, for instance, they have to use vacation versus state leave. They get to choose which bucket they use for the event in question. Finally, again, there will be another notice. Can't have a law without a notice. The IDO has not, released the notice yet, but they're promising that between now and the end of the year. There will be, additional record keeping requirements for employees' use of state leave. You have to keep that for a minimum of 3 years. And again, the Department of Labor through the Attorney General Office can enforce any violations of the policy. Now, again, the Illinois Department of Labor is trying to provide, as much practical guidance in terms of how they view the Act's requirements, and they are been updating the frequently asked questions with some practical guidance. So I've clicked the link here. Again, if you just go to the Illinois Department of Labor webpage, you'll be able to find it as well. And it's been updated as of earlier this week, or last week, excuse me. They also have had a series of webinars. I actually sat in on one of them a week ago. It's an hour long. They have 2 more. They're helpful. They're providing, trying to provide some practical advice. So again, I encourage you, if you have time for the one of the next 2 seminars, to log on as well. And the Illinois Department has promised to issue proposed regulations providing further guidance to employers. by the end of the year, and hopefully being finalized before, March of next year. The one other requirement I neglected to mention, if you're going they accrue 1 hour of use for every 40 hours worked at the time of hire or January 1st. There is a 90-day waiting period under the law before an employee can start using their state paid leave. You're of course free to allow them to use it earlier than 90 days, but worst case scenario, they can't start using it until after March 31 next year if you go the 1 hour for every 40 worked. If you front loaded the full 40 hours, they have a right to start using it even if they haven't technically earned the full 40 hours. And if they use the full 40 hours and quit 2 weeks later, you will not be able to recoup the advance. If you go the accrual route and you advance someone some time, you may be able to recoup that so long as that's authorized in writing at the time of the advance. But again, that's another consideration to keep in mind as you try to think through your policy going forward in terms of managing the obligation here. So I'll hold questions for right now and get those at the end of the program, but I know there'll be a lot of questions here, and we'll try to get as many of those at the end of the initial presentation here. Next act I want to talk about is the Temp Worker Fairness Protection Act that passed this summer, and this is going to be applicable to employers who have staffing employees as any part of their workforce over and above their existing employees. So it was signed by the governor on August 4, and it became effective immediately upon signing. So there was no phase in for next year. And there's a number of different components to this act that's going to impact all employers. And first and foremost, again, these are, individuals who are working for you through a staffing company. So strictly speaking, they're not your employee, they're the employee of the staffing company. And so the staffing company has a number of disclosure obligations. Of course, they can't comply with their their notice obligations unless they get information from you. And if you fail to provide information, there's liability to the employer, to the staffing agency. So the first, notice obligation that the staffing agency has, and they'll expect you to certify that this is not applicable here, is that you're not having people coming into your operations because there's an ongoing strike or lockout or other labor dispute. Strike and lockout is usually easier to understand. The way the statute defines a labor dispute and the way the Department of Labor is proposing to define the labor dispute is very broad, and so we're trying to work through some issues there. But if you're getting staffing individuals because you have an ongoing labor turmoil with your unionized employees, there's going to be a notice obligation that you have to the staffing agency and the staffing agency has to the individuals, because they have to inform that individual that they're being assigned to a work site where there's an ongoing labor dispute. And failure to do so will obligate both the staffing agency and the worksite employer to monetary penalties, up to $500 per person per violation, together with any legal expense if there's an enforcement action. So again, if you have a number of individuals staffing a labor strike, those penalties can add up real fast. The next requirement I want to talk about, and this is frankly the most difficult and most problematic, is if you have individuals that are working for you through a long-term staffing arrangement, and the statute defines that as 90 or more work days. So you have to pay them the equivalent, or I should say the staffing agency has to pay them the equivalent of the equal wages that your employees are receiving and the value of their employee benefits. And again, the obligations on the staffing company to pay equal pay and equal benefits, they have an obligation to ascertain that amount and that cost from you failure to provide that information, subjects the worksite employer to enforcement penalties and liabilities, either to the individual who's not paid equal pay or equal benefits, or the staffing agency who fails to pay the equal pay or equal benefits. And the pay rate has to be whatever the equivalent hourly rate that you're paying someone who's performing the same or similar job as the long-term staffing employee. And again, if you don't have an exact match, you have to try to compare your existing workforce for what the staffing individual is, providing to you to determine what's their hourly rate, so they can receive the equal pay and equal benefits. So you're going to look at skills and responsibilities, working conditions, and again, the equivalent benefits. Now, this is frankly the real hard problem here is, the staffing agency may offer health insurance benefits to the employee that's assigned to your work site. They may even offer a 401k plan or a retirement plan. But the statute obligates them to provide equivalent benefits that mirror the worksite employer's plan, not the staffing agency's plan. And so if you can't provide, and most worksite employers cannot add these individuals to your health insurance, your retirement plan, because by definition, they're not your employee. And so instead of providing the similar benefits, you have to come up with the monetary equivalent. And frankly, the statute doesn't define how you calculate the monetary equivalent. The only Department of Labor is struggling with how to provide guidance to that employer. And so the potential good news here, too soon to tell, is the legislature is back in session this week and another week in November for the veto session. There's at least, some effort to pass a bill either this week or next in middle of November to at least stay this part of the act requiring equal pay and equal benefits until, frankly, the legislature, the Department of Labor can come up with a way to how do you quantify benefits, because it's defined very broadly right now. So that's stay tuned for that. But if the act is not stayed, and again, it was signed and effective August 4th, then come mid-November, mid-December, those individuals that they've been working for you full time since August 4th are going to get to that 90-day threshold, and that's going to be required the equal pay and equal benefits if you're going to continue to employ those individuals through the staffing agency. So again, you have to provide, the pay and benefit information that you provide your employees to the staffing agencies so that they can determine how much they have to pay the individuals from day 90 forward if they're still placed at your work site. And again, failure to comply, triggers more monetary violations as well as potential damages to the individual who wasn't paid the equal pay and equal benefits by the staffing agency because you didn't provide the information to the staffing agency. So the Illinois Department of Labor has enforcement responsibilities here. The statute also permits the Attorney General to file enforcement action. And then more problematically, the statute also identifies that other interested parties who is not defined can file a lawsuit as well. So obviously labor unions can file lawsuits even if they're not representing your employees. There's other worksite, fairness groups out there who are advocating for changes. They can file lawsuits, to challenge whether or not the staffing individuals are being paid equal pay and equal benefits. And so, if you've heard about the onslaught of the BIPA litigation in Illinois, the Biometric Information Privacy Act, this too can be another litigation boom for the plaintiff lawyers going after employers who may or may not be paying the equivalent pay and benefits to long-term temp employees that are assigned to their work site through staffing agencies. Now, the good news is the interested parties have to at least start the IDOL who has to review it, and they can't go straight to court. If there is a legitimate issue, the employer and the staffing agency have 30 days to cure. The IDOL has up to 6 months to remedy the complaint if there's a violation. However, they can issue a right to sue notice to the interested party, so they can go straight to court. My fear is, the IDOL is already understaffed as it is. They don't have the resources or the staff to do full-fledged investigations. So my fear is they'll just simply issue the right to sue notice and let the advocacy groups, sue here, because they can keep 10% of what they recover, plus, cover attorney's fees and expenses. So this is, an act with all kinds of legal peril for both staffing agencies as well as their clients. The third prong of this act requires the employer to notify the staffing agencies of any potential safety hazards that the temp employees may encounter at the placement, so that staffing agency can in turn provide appropriate safety training to the individuals that they're placing there. Again, if other safety issues are brought up during the placement, the staffing agency has a legal duty to reach out to the employer to require, appropriate safety mitigation measures. And again, failure by the worksite employer to address it or provide the necessary training, again, creates legal jeopardy for both the staffing agency and the worksite employer. Also, the staffing agencies are now required to advise every individual they place with a worksite employer of both the hotline and the phone line for the Illinois Department of Labor, so they can report affirmatively any safety hazards that they perceive in the workplace where they feel like they're not otherwise being provided appropriate training or protective equipment. And again, they're protected from retaliation for making any reports either back to the staffing agency or to the IDOL. Finally, if the worksite employer is providing the safety training upon the placement, the staffing agency has a duty to review that training and ensure that it's both appropriate and fully effective on all, again, anticipated hires at the workplace. A lot of this requirement, unfortunately, grew out of the tornado that hit the Amazon worksite in Edwardsville, December of 2022. Because a lot of the folks there, when that tornado hit, didn't know where they were supposed to go in terms of tornadic conditions, and so that's what sort of drove this training obligation as being part of the act. And again, both the staffing agency and the worksite employer are legally charged with ensuring that the appropriate training is provided to every individual. Now, as I mentioned, there may be a bill that stays the equal pay and equal benefit part of the act. That bill will likely not stay the notice obligations for labor disputes or the notice and training obligations for safety hazards. So again, for folks who are there, at your work site, once they hit day 90, there's going to be a lot of increased scrutiny from the staffing agency towards the worksite employer, and the worksite employer is going to have to share a lot of information with the staffing agency if those individuals are continue to work at the placement site. So now I want to quickly shift to the obligation to affirmatively disclose salary and benefit information for all future applications. This is a trend that's been passed in a number of other states in the last couple of years. So there's already been 4 or 5 states that have similarly passed such disclosure obligations. Illinois joined that group this year, and the State Equal Pay Act was amended to require all employers with 15 or more employees starting on January 1, 2025 to include appropriate pay and benefit information for the job for which they are seeking applicants in all job postings going forward. And it has to be for, either a job that would be performed at a work site in Illinois, or if you're hiring someone remotely who may live in St. Louis, but they'll be reporting, to, an Illinois-based employer, even though they may be working remotely outside the state of Illinois. This disclosure obligation is going to apply to that person if their, reporting contact is someone working in the state of Illinois. Now, again, a lot of people may use Indeed, for instance, for job postings. And as I understand it, Indeed oftentimes will include industry average pay and benefit information for the posting, even though that may not mirror what you're offering or intending to offer. That will not be sufficient starting in January of 2025. So you have to ensure that when you post a job opening, you're identifying the proposed wage or salary for that opening, or at least a range, so you can have some flexibility depending on the applicant's experience or qualification. And then you have to, make sure that that's included either directly in the ad, or if it's online, there's at least a hyperlink that takes the person to the applicable information for the salary or the compensation terms. Benefits likewise have to be described, in a good faith manner about what will be offered for either the position in question, including, health insurance, retirement benefits, any incentive compensation, any stock options or other equity, benefits, if they're applicable. Whatever you would propose being part of a job offer has to be disclosed affirmatively when you're, advertising for applicants. Failure to include that information, again, either in the ad itself or at least through a hyperlink that the applicant can access, is going to be unlawful. And again, if you use a third party, whether Indeed or any other third party, to host or post your job postings, it's going to be your responsibility to make sure that you provide them the applicable information so that they can include it in the posting. So you will not be able to rely upon the fact that Indeed may post industry figures for salary or benefits. And then finally, if you're going to post a job externally, you're going to be obligated to, within 14 days of that external posting, inform all your internal applicants of the job opening, which again, may not seem in most instances to be problematic, but occasionally an employer, particularly if it's a higher level opening, may do a blind ad or a confidential posting because they frankly don't want the candidate, they don't want the current incumbent to know that they're soliciting resumes for a new CFO. Not good for job security if you realize that your employer is currently soliciting external applicants for your job. And so if you're going to do a confidential blind ad, keep in mind that, after 14 days, you're going to be required to internally post that opening as well. Now you can still do, a word of mouth confidential search. So you may have to hire a headhunter to do the search rather than doing a posting, because you're not obligated to post externally. But if you do post externally, you also have to do an internal announcement as well. Again, this is a year and a few months away from being, applicable, but keep this in mind going forward. Again, the Illinois Department of Labor, once again, is tasked with enforcing the act. First offense of not posting the actual salary and benefit information will give you a 2-week period to cure the mistake, and a fine up to $500. The second instance will be only a 7-day cure period and a $2,500 fine. And any further violations, the third strike on, no cure period, strict liability, fine up to $10,000 per violation, in a job posting for one position is a single violation. So you get two sort of I don't say free passes, but you at least have lower fine responsibilities. But after your first 2 strikes, every violation thereafter could have significant monetary penalties. Again, that's the bad news for next 2025, but I want to alert employers now to it. Now, the next act I want to talk about is the Illinois Gender Violence Act. This, again, is a statute that many employers don't know about, but the plaintiff bar has recently seized upon it as a way to bring an additional legal claim, typically out of a harassment situation. They may already bring a sexual harassment claim under Title VII or the Illinois Human Rights Act. If there's any sort of physical contact as part of the harassment, they can bring a separate statutory claim under the Illinois Gender Violence Reporting Act. And so this was a civil action where you didn't have to go to the EOC or the Illinois Department of Human Rights. It provided greater remedies, at least under the Illinois Human Rights Act, which doesn't permit the plaintiff to recover punitive damages. And it allowed, again, claims based upon physical aggression or invasion of someone's, zone of privacy that's based on a sexual nature or gender-related violence. And so now the amended act will include, all domestic violence that's otherwise described within the meaning of VESSA, which contemplates, far more forms of, violence than just sexual assault or other crimes of a violent physical nature. So the slight good news is the statute was amended to at least permit an employer to try to seek a safe harbor from having to defend a gender violence claim. They may still have to defend a Title VII or Illinois human rights claim of sexual harassment. But the gender-related violence, has to occur between the victim and the plaintiff, who's your employee, while the victim is at least, working for you and performing duties. And so right now we've seen claims where it's away from the workplace, but it's 2 people that work for you. And so the statute will try to rein that in now, that it has to occur at the workplace. The physical violence has to be the proximate cause of the injury. And that's defined as there's a substantial factor between the behavior and the injury. And the employer finally, had acted in a manner that was inconsistent with how a reasonable employer would act. So the plaintiff has to establish that you acted in a manner inconsistent. And the good news is as everyone may remember or know, Illinois requires, annual harassment training of all employees. And so if you comply with that obligation and you're training employees, annually, then that allows you to claim the safe harbor, because the employee, or the plaintiff, absent some other failings, won't be able to establish that you as the employer acted in a manner inconsistent with its legal obligations. So failing to train is, again, acting in a manner that's inconsistent. Or if you're training, but you're doing a poor job of actually promptly reviewing and taking appropriate action when employees complain thereafter, again, that can jeopardize the safe harbor here. But if you are doing the annual training and then you promptly review and investigate and take appropriate actions for all internal complaints, again, we may still have to defend the sexual harassment case in that instance, but at least we won't have to defend the separate gender violence claim. So again, it's important that we, not only ensure that our training is being done properly and timely, but that when and if someone complains internally, we handle it, in a timely fashion, in an appropriate fashion. Again, as many of you may know, Title VII, Illinois Human Rights Act, requires someone to file a charge within 300 days of the last act of harassment. or their claim is barred. The gender violence claim, has a much broader, statute of limitations. So this claim can be brought, 4 years after the fact. So again, it can be a claim that someone can bring if they're otherwise barred from bringing a Title VII claim, and you haven't done the training. So that's why it's important to have the training to close off this, what otherwise would be a Hail Mary claim for the former employee if they didn't timely notify the employer or the EOC about the current harassment claim. And then one other thing, if the employees are under the age of 14, the 4-year statute of limitations doesn't begin to run until they hit the age 18. So if you have 16-year-olds working for you, they have essentially a 6-year statute of limitations for any acts of violence that occurred while they are working for you before they hit the age of 18. Along the same lines, we've amended VESSA again, became effective upon the governor signing in July. Currently, VESSA permits a leave of absence for employees who are dealing with domestic violence, gender violence, sexual violence, involving either the employee, him or herself, a family member of the employee, a household member of the employee. So that's what VESSA already covered before the 2023 amendments. Historically, the leave under VESSA for one of the qualifying reasons could be taken because the victim or the family member needs to obtain medical care, counseling, or seeking safety protection services from victim service organizations, going to court seeking legal protection, or getting trained on safety measures. The new amendments now expand upon these qualifying reasons and provide 3 new reasons that someone can take a leave under VESSA if themselves or the qualifying member is a victim of domestic violence. That would include, God forbid, but unfortunately in the area of domestic violence, fatalities are a reality. So the employees now would be able to take time off to attend the funeral or any, memorial services associated with the victim who was, fatally affected. Make the necessary arrangements for the funeral or memorial service and time that they need to grieve. Now that also would cover, be contemporaneous with FMLA if your employee is FMLA eligible, but if you're not an FMLA covered employer, again, this would be a situation where they would be able to take time off to grieve after the domestic violence. Employers will be able to require documentation for the qualifying reasons, either the original or the expanded. Now, the 3 new circumstances are limited to, no more than 2 weeks or 10 work days, have to occur within, again, 60 days of the death. There is some overlap with the Family Bereavement Leave Act that I'll talk about in a moment. So employees will not be able to double dip here, but the Family Bereavement Leave Act would permit someone to take, up to 6 weeks off. So in that sense, if they elect to go under that act versus VESSA, they'll get more than the 10 work days. But to take the Illinois Family Bereavement Leave Act leave, which is a state law benefit, you have to be an FNA qualified employer. So if you don't have 50 or more employees in a 75-mile radius, then the individual will not be entitled to take the bereavement leave under the Illinois Family Bereavement Leave Act. I know this is complicated and you almost need a flow chart after a while, but that's, again, another option out there if we're dealing with the domestic violence that, God forbid, resulted in a fatality. And again, the family, they don't get both, so they don't get the 10 days under VESSA and 6 weeks under family bereavement leave, so they're still capped at the 6. And then finally, We'll also talk about, a new law, the Child Extended Bereavement Leave Act, which is different than just the Family Bereavement Leave Act, and I'll explain that difference in a moment. So let's talk about the Child Extended Bereavement Leave Act that was passed this year. So it's also referred to as Zachary's Parents Protection Act. And again, this is dealing with every parent's worst nightmare, the death or suicide of a child. In this particular instance, a mother up in Rockford, her son committed suicide, and she was terminated from, by her employer when she tried to take time off to grieve her son's death. She was not covered by FMLA because the son was over the age of 18, or she may not have been an FMLA required employer, but in any event, she did not have any legal right to take time off to grieve in that instance, even though, again, her son had committed suicide. And so now, if you're a non-FMLA qualified employer and you have an employee who has a child who's either murdered or committed suicide, they're going to be entitled to leave. And a child is, of course, defined consistently with FMLA. It can be both a biological child, a child that was adopted, or a foster child for the employee, their stepchild, someone that was a legally ward of the employee, or someone in loco parentis. The employee may not have been a parent, but they raised the child, even as if they were a parent. So if you're a large employer with 250 more employees, or if you're a small employer between 50 and 249, in this situation, your employee will get up to 12 weeks. If you're a large employer, if you're between 50 and 249, your employee after a death or suicide will be entitled to up to 6 weeks of leave after the death and suicide of the child. Again, to the extent you're covered by FMLA as well, you want to make sure that the leave is being designated under both, so they don't be able to stack on top of the 12 weeks, because again, typically the parent here is dealing with their own personal grief, which is a serious medical condition themselves. So you just make sure that even if they're electing the leave under the Child Extended Bereavement Leave Act, you're also designated under FMLA as well. They have up to a year after the death or the suicide to take leave under this act. God forbid, I've never, had to experience this trauma, but I know friends and people who have, and they tell you, you never get over the death of a child or a suicide. And my grandfather never got over the fact that, his son predeceased him when my uncle was the age of 40. So someone may have grief long after the death or suicide, but the leave benefits under this law will expire a year after the death of the child. Again, ordinarily you'll be required to, the employee will be required to provide sufficient notice when they're taking time off, unless it's impractical or they weren't able to provide advance notice. Now, if you have paid, again, sick leave available or PTO benefits, even though this leave may be unpaid, like FMLA, you can require employees to use or burn whatever policy benefits you provide to employees, with the exception of if you do keep a separate bucket for the state leave under the Paid Leave Act for All, you can't require them to burn those hours while they're off on the extended bereavement leave, but you certainly can require them to use and burn all other paid benefit leave time that you provide under your policies. And again, so long as you contemporarily designate the leave under both FMLA and any applicable state law, they cannot stack it on top of, the 12 weeks that FMLA, provides, but it's the employer's responsibility to duly designate in order to avoid that stacking. And then if the employee takes the leave rights that they have under the Extended Bereavement Leave Act, they cannot then use or stack bereavement leave under the Child or Family Bereavement Act. And again, the Family Bereavement Act just deals with any death of a family member or a son or a daughter, whereas the Extended Bereavement Leave Act only deals with murder or suicide. So family member or a son or daughter, if they unfortunately die from cancer or die in a car accident, again, trauma is the same, but it doesn't trigger the Extended Bereavement Leave Act benefits because it's not a murder or a suicide, unless they argue that the car wreck was a suicide, or you hear the situation of a suicide by cop. But again, that's a nuanced problem, and we'll deal with that on a case-by-case basis. Failure to provide the benefit, for a covered situation is also protected by the Illinois Department of Labor, and of course, use of the benefits is protected from retaliation. If there's a violation, the employee can recover any damages or lost wages. And again, penalties, first offense $500, second offense $1,000. Again, employee will bring the claim, has a 1-year statute of limitations to it. And then, the claim would be barred. Finally, the last couple of things I want to talk about, and then I'll open up for questions. As many people may remember, the Illinois Personnel Records Relief Review Act allows employees and former employees to, request the opportunity to inspect their personnel file or any personnel records up to twice a year. And, the employer's obligation currently was to permit the physical inspection at a reasonable time and place. And then the employee had the right to request copies, and then the employer would have, an obligation to make copies, charge a reasonable cost for the copies, and mail the copies to the employee after a request. Starting next year, the employer will be obligated to, email a copy. Right now, lots of lawyers will make demands on behalf of their clients, say email them, and we can sort of frustrate the process and say, we're not going to, just copy them and make an email to make it easy. You have to come in and inspect it, pick which copies you want, and then we'll mail them to you later. Now, starting next year, the employee, either themselves or through their legal representative, can demand an email production after the inspection has occurred. New obligation here for employers that may classify some individuals providing services as employees versus as an independent contractor versus an employee. And if you do have individuals providing services as an independent contractor versus an employee, I would caution you to make sure you've reviewed that with your legal counsel, because more often than not, an individual providing services as an independent contractor versus a W-2 employee is typically misclassified. Normally, those remedies or liabilities are under federal law. So Illinois is trying to attack that problem now. And starting next year, again, most employers, you're already familiar, when you hire new employees, you have to notify the Illinois Department of Employment Security that, starting, January 15, Charlie and Jane are our new employees. And we'll be submitting, again, payroll information and unemployment premiums for those employees. Next year, if you have any individuals that are, classified as an independent contractor, you're gonna have to notify the IDES. Now, if this is not a business, but if you've got, someone who's working as a W-9 independent contractor and they're an individual, you have to notify the Department of Employment Securities, and this is going to be, a flag to them to come in and audit you. And they will look at that situation carefully. And again, Google the ABC test. That's the test that will be used to determine whether or not this person is appropriately classified as an independent contractor versus misclassified as an employee. And so, this will be a flag to the Illinois Department to audit the situation, and if there's a misclassification, they will again potentially, seek, past contributions for unemployment, workers' compensation, and other payroll taxes that were not properly withheld. Final thing I want to talk about is the changes to the Blood and Organ Donor Leave Act. So historically, the only Employee Blood Donation Leave Act has been on the books for a number of years. It's now being renamed the Employee Blood and Organ Donation Leave Act. Before, employees could donate blood on a regular basis and be entitled to take time away from work to do so. This is only applicable if you're otherwise an FMLA covered employer, so you have to have 51 or more employees. But if an employee wants to donate an organ, and the statute defines a number of organs, including kidney, liver, lung, pancreas, intestines, bone, or skin, they now have time to take away, up to 10 days in a 1-year period to be an organ donor. Again, I don't know many employers that would say no to that, but now there's a legal obligation for an employee to take up to 10 days off unpaid if they want to be an organ donor as opposed to just giving blood. And the last thing I want to talk about before a few questions was actually a bill that was vetoed by the governor this summer, but may be overridden either this week or during the second veto session in November. So this was an act that amended the Right of Privacy Act. This is only applicable if you otherwise are using E-Verify to screen your applicants. But for those employers that subsequently receive a mismatch letter from the Social Security Administration, which basically says, hey, the name and number don't match, this act would have basically mandated some job protections for those individuals, while you're trying to clarify the mismatch. Typically there is no, you're not required to keep someone on board if the name and the number don't match. And so this act would have mandated some job protection privileges while the mismatch was being vetted. Again, the governor vetoed it. It may be overridden, so we'll stay tuned on this one, whether or not it kicks in next year or not. But essentially, if it does get, the veto does get overridden, then the individual will be able to continue to work for at least 30 days while they're trying to clear up the discrepancy. So watch for this one going forward. So at this point, that's the end of my presentation. I know I covered a lot. I covered it really in a quick manner. I appreciate your patience staying with me an extra 20 minutes. So out of that, I'm going to be more than happy to stay on even longer for your benefits and try to give you as many practical guidance as I can to watch forward going forward.
Thank you so much, Tom. So everybody, there is a question box in the bottom of your GoToWebinar pane or a chat. You can type those questions in directly to us and I can relay that to Tom. It looks like we do have a couple coming in. Let's see here. We have, if we have a 90-day probationary period and the employee is separated from us, sorry. If we have a 90-day probationary period and the employee is separated from us before then, are we still required to pay out?
If you front loaded it, yes. If there was just an accrual of 1 hour for every 40, then no, there's nothing to pay out because they didn't have an entitlement to it. But the DOL takes the view if you front load it, then you've given it to them then. But otherwise, if you're doing the 1 for 40, they can't use it for the, until after the 90-day window anyway. So in that situation, the accrual would go away with no payment obligation.
If an employee tries to use the Illinois Paid Leave Act for a scheduled overtime shift on a Saturday, is that allowed?
If they have, well, under the statute, the answer would be yes, because they had the right to use it with no notice. Now, part of the good news, and again, I point your attention back to the Illinois Department, their FAQ, specifically question number 10, the employer, the IDOL is taking the view that an employer can impose some operational requirements that would preclude the use on a whim of State Leave Act, provided it's clearly outlined in the policy that was distributed to the employees. So if your policy makes it clear that you cannot use state leave there if it's a mandatory overtime, then you could deny it if they try to use it. But short of that type of limitation being included in your policy, they would be able to use it even if they call in that morning or that afternoon, depending when the shift is. So again, devil's going to be the detail and the policy, and also we need to watch for what's the department going to say in terms of the conundrum about foreseeable versus unforeseeable. What rights, if any, does the employer have to verify that you're using it for an unforeseeable reason and couldn't have given us 7 days notice? So that's another open question to watch how the IDOL addresses that. I actually posed that question during the last training webinar, and they basically said, we'll get back to you on that one. So hopefully they'll give us some guidance, either an FAQ or the regulations that they tend to release before the end of the year.
Right, a couple more questions coming in. If the employer already allows 40 hours in their first year because they do not accrue leave until year 2, do they have to add another 40 hours or are they already doing what is required?
Now, if they can't use time during their first year, then they're gonna have to, at a minimum, accrue one for 40 that they can start using once they're past 90 days. So, and again, even if you go the front loading, then they have it in the first year regardless. So again, that's another thing we have to look at, during the first year of employment, they have at least a minimum guarantee of 40 hours, whether you front load it or allow them to accrue it during the year after 90 days. So they wouldn't have 40 after 90 days, but whatever they have in their bank, their state leave bank, they would be able to use in that first year. And then again, with the accrual, whatever's unused at the end of the calendar year would roll over to the next year, still remain in the bank on January 1 of 2025.
Another question coming in about just the no notice for the policy. So they can miss a shift, basically no call, no show, and after that claim PTO?
The way the law is written, yes. Again, hopefully we'll get some guidance that would obligate the employee to establish that notice was unforeseeable, or the circumstances were unforeseeable and they couldn't give prior notice. But that's an open question right now. Now, if they're truly no call, no show, and try to seek it after the fact, I don't think that's going to fly. But if they call you up that morning saying, it's game 7, I stayed up too late watching the World Series, I'm not coming in today, you're really at the mercy of the employee at that point under the state leave law. You can enforce your notice requirements for all other leave that you provide as a matter of employment policy, but at least have to have a minimum of 40 hours that they can use at a whim. Not an ideal situation, I grant you that.
A couple more questions here. If our vacation policy requires 24-hour notice and the Illinois Paid Leave Act is in a different bucket, we can mandate that if they call in the next day, that they take the Illinois paid leave time they have available?
Well, they get to choose, so they would be ineligible to use your other policy bucket, and so at that point they would have to, if they want to take time off, they'd have to burn their 40 hours. So you can enforce if you keep separate buckets, then you can enforce your notice rights under your other buckets of time. Or it's an unexcused absence if for whatever reason they don't want to take it off, but use it. But in that situation, as a practical matter, they're going to have to use the state leave bucket. Otherwise, it's an unexcused absence under your attendance policy.
With the rollover, it can be capped at 40 hours per year being used. Upon separation, is paying out capped at 40 hours as well?
Well, if you go the rollover and you keep it separate from vacation or PTO, then it's not paid out at separation. So they may have lots of hours accrued, but unused, you wouldn't have to, pay it out. Again, the challenge is most employers don't want to have the administrative headache of tracking it separately from either the vacation time. The temptation is just to roll it all into your PTO policy, then that has to be paid out. So again, that's the real conundrum there, is that, if you keep it separate, you avoid the payout. But time will tell how much time people will book up if they roll over. But if you keep it separate, there's no payout obligation unless you front load it.
All right, great. Well, that wraps up the questions for today. I definitely appreciate everybody taking the time this morning to hop on with us and join. I know that is a lot of information. So if you guys have anything that you did want to ask, I'm sure Tom would provide his contact information, and I'm happy to give that to you all. Tom, are you going to make the slides available to the group?
Yes.
Okay, great. And so before we wrap up, I wanted to say too, me at a higher level here, we've been talking to customers and Illinois business owners lately about their processes and, paper time cards. And, if that sounds like you, if you feel like after the call today that you need a facelift basically on your policies, we're happy to help with that. We do have a demo coming up for our timekeeping software, and just happy to have a consultative call with you. You can reach out to me directly at hello@higherlevel.com, and I will connect you with the resources. We will be sending out the recording and the slides, so you'll have that to refer back to, and we'll kind of stay tuned as things transpire over the next couple of weeks and go from there.
And again, thank you everybody for being patient with me as I navigated through my technical challenges today. So I appreciate that I took more of your time out of the day, but hopefully it was beneficial for you in the end.
Yes, absolutely. Thank you all again, and have a great rest of your day.
Take care, everybody.
Thank you.